Welcome to SAHR's podcast to bring together distinguished female lawyers who have been at the forefront of strategic litigation initiatives to address sexual and gender based violence in their respective countries. My name is Lara Danani, and I'm a legal intern at SAHR. And before we begin, I'd like to share SAHR's vision. We envision a world where women and diverse leaders, especially those who are underrepresented, are able to exercise direct responsibility in decision making processes and systems in their countries, with the goal of ending sexual and gender based violence. Sahar's mission is resourcing women and diverse leaders who are shaping sexual and gender based violence laws and policies. If we want a more equal and accessible justice system that works for sexual and gender based violence survivors, we need to invest in inclusive leadership and decision making in the law and policy space. Our hope lies in emerging leaders who are committed to deep systems change. In today's event, you will hear from two panelists. They are Ms. Ranjita Silwal and Ms. Isabella Mwangi. Ms. Ranjita Silwal, a human rights lawyer in Kathmandu, Nepal, has an impressive career of over a decade, marked by unwavering dedication and expertise in the field. She has worked closely with both national and international organizations, advocating for human rights and supporting victims of rights violations. Her pivotal roles in program implementation and effective coordination have been crucial, especially in areas like women's rights, peace and security, and gender justice in Nepal. Ms. Isabella Mwangi, a lawyer with over 7 years of experience in human rights, is a passionate advocate for the rights of children and women, with a specific focus on achieving gender equality. Her extensive work includes grassroots level efforts to combat sex and gender-based violence, such as supporting Kilifi County in drafting a comprehensive gender policy. Isabella's influence extends to training and empowering state actors on gender based laws and their practical application. Notably, she was appointed by the Chief Justice to serve on National Council and Administrative Justice Committee, tasking with reviewing laws related to sexual violence and gender based violence. Thank you for joining us today, Isabella and Ms. Ranjita. And now we can start to the moderation of the session. So I'd like to begin by asking both Ms. Isabella and Ms. Ranjita, can you share a bit about your background and what motivated you to become involved in strategic litigation against sexual and gender-based violence?
Um, Hello, everyone. Good morning. Uh, Thank you so much, Lara, for the introduction. To introduce myself, I am a human rights lawyer based here in Nepal, and I have been very much connected with the issue of women rights from the beginning of my career, so to say. And I began my career as a researcher. Uh, I researched on the implementation of the laws related to sexual violence in Nepal and comparing it with the international standards. So that's how my keen interest on the laws related to sexual violence developed at that time. And thankfully, I started working on the issues related to sexual violence and rape in Nepal. And I think it's the consistent work that I have been doing in the area itself that developed my interest and knowledge itself in the issue. And that's how I came to like with time and it just felt unfair, like how things were even in laws and in the society, and how women have to face it. That's what motivated me to take my foot front in a strategic litigation. Thank you.
Good morning, good afternoon from wherever you are. Thank you very much for this opportunity and very nice to meet you, Council Rajita. Um, so for me, the strategic litigation actually just happened to me. For me, what I was doing was I was raised in a very feminist home, and um, interestingly, I never went to school with any boys. So the only boys I knew in my life were my father and my brother, and there was nothing different in that regard until now. When I was an adult, I'm in campus, and I started noticing the nuances of boys and girls being treated differently. And that was shocking to me because the world that I know is we are all equal. And so when I was a bit younger in my profession, I was posted in a county called Kilifi County. And the distinction of the roles, the societal roles of boys and girls, men and women was very clear. And it was even more disturbing knowing that these are my sisters and I am not too far from befalling the same acts that has just befallen on them. And so I quickly had to change. It started as a passion of wanting to understand why women think they're second class citizens, why they're happy to be there. And I then started doing pro bono cases for women who needed custody, for women who needed care, support for their children. And then slowly, for me, it became almost automatic that as a woman, this is what is going to be for me. And someone has to start taking charge and changing what society thinks about the role of women and girls in the society. And so for me, it was more of a passion that then turned into a profession.
Thank you for sharing, Miss Isabella and Miss Ranjita. And my next question to both of you is, could you please share a bit about your current work in the field of strategic litigation on SGBV in your respective countries?
Uh, yes, sure. Currently, I am engaged together with five other female lawyers in a public interest litigation that we have filed with the Supreme Court of Nepal to extend the statute of limitation, not to extend, but to remove the statute of limitation related to the cases of rape so that the victim can go and access the justice system whenever they feel comfortable, given many stigmatic and other barriers the victims might have to feel. So this is what I am currently engaged in. Thank you.
So for us, so ours comes in two folds. We have a legal aid clinic that deals with the day-to-day usual intimate partner violence, rape, defilement. But in regards to strategic litigation, two things have happened. We have done strategic litigation around the contribution and attribution of women on matrimonial property, a law that is very punitive for us as women in Kenya generally, but also across Africa, where a woman has the burden of demonstrating how she has contributed towards the wealth, the creation of wealth and resources of, of the family, as opposed to just the husband being there. So, especially where the wife is not working and you cannot be able to demonstrate your financial attribution. And so we have had several litigation cases um, on what it means to demonstrate attribution, especially, and the silent economy. The things that women do behind the scenes that are not financial in nature, but then contribute to ensuring that the home is running smoothly to allow the man to be able to go and work and bring the money back home. So this also led to us, my organization with other partners, uh, doing a documentation or rather an interpretation of what our regional instrument called the Maputo Protocol, Article 7 on matrimonial property, what that entails and what that looks like, and how then that translates into domestic laws within the various states. And I must say, we still see jurisprudence that is a bit erratic, where one day we have fantastic jurisprudence, and then on the other hand, another court then goes ahead and gives us jurisprudence that regresses. So we are still not where we need to be. The second strategic litigation that we are currently doing, and as an organization, we have been enjoined, we're actually waiting to see if we'll be enjoined as interested party. We did apply to be interested party, is the issue of minimum mandatory sentencing as prescribed in our Sexual Offences Act. And because what we are seeing currently is courts are starting to push back on the utilization of minimum mandatory sentencing. So this is just something that we've just started, and yeah, that's where we are at the moment.
Thank you. Isabella, could you share a little bit about the court's interpretation and utilization of the minimum mandatory sentencing in the SOA?
Right. So let me just give a very brief background. For a very long time as a country, in the early, before 2006, sexual offenses were being taken to court on grounds of the penal code. And so what you'd see is one court would decide there was no consistency on the sentencing, on the remedies provided to survivors of gender-based violence. So come 2006, we got our first Sexual Offences Act, and it came with the prescription of minimum mandatory sentencing, where it has articulated that if you defile a girl less than 11 years, it's life sentencing. If you defile a child between 12 and 16 years, not less than 25 years. And the same also on matters rape. And this has been the practice since 2006. However, the last maybe 2 years or so, we have seen court pushing back on the utilization of minimum mandatory sentencing. And you see the drafters of the law then, of that particular legislation, the spirit of minimum mandatory sentencing was there, one, to be able to offer a prospect of justice to survivors of sexual violence, simply because we understand how it is such a grievous violation of one's personal rights, as well as, so you, for sexual offenses, it could be considered in the two groups of individual rights and group rights, right? Because sometimes, when we normalize this, as an individual, it becomes a problem, but also as a group of women, as the female or the half of the society is also aggrieved. And so for us, it was we must be able to at least arrive to a prospect of justice. Then, secondly, it was also to deter and and be able to guarantee non-repetition. Recidivism. To ensure that if you're in for either 25 years, at least for a period of time, you're not going to be in contact with the community. And the third one was also, of course, rehabilitation, being able to understand what is the root cause of this. However, the same logic is now what court is applying to demonstrate and say the minimum mandatory sentencing is limiting discretion of the court. It is not allowing judiciary or the judicial officers to arrive at a remedy or a conviction as per their discretion. And of course, that is for me a very flawed reasoning, because it's clear minimum mandatory sentencing gives you a threshold. It gives you it's a timeline, and not necessarily telling you this must be the number of years. Then secondly, of course, the question or the concept around whether it really does deter recidivism or non-repetition of the offense is something that has come over in court over and over again. On the basis that why is it we are still seeing, despite the harsh penalties, recording high numbers of sexual offenses? Why is it still the most popular cases in court? And so people are starting to interrogate that perhaps these harsh penalties is not the way to go, and it's not the way to resolve a social ill. So a lot of theories and concepts have been raised in that regard. And then thirdly, we're also very cognizant of the fact that I don't know whether that is also the situation in your country, Council Rajita in Nepal. We are still dealing with a very patriarchal judicial system. And as long as it's men sitting in these spaces, men who have also managed to somehow ensure that the system is patriarchal in nature, whether it's a man or a woman in that seat, we are definitely going to see this pushback, because the system reasoning is still very male centered, it's still very patriarchal centered. And so for us, this is what is happening with the minimum mandatory sentencing. And so we, our team, the organization and some of our partners have applied as amici and as interested party just to be able to demonstrate to court, look, this is the role of minimum mandatory sentencing. These are the number of cases. This is what we mean by saying sexual offenses has a huge impact on women and ultimately on the economy of the country. And so we are yet to see what that will be the outcome, but we are hoping on our end, I think we have put our best foot forward by providing sufficient evidence and information on the same. Thank you.
Thank you for sharing, Isabella. Um, my next question is to Ms. Ranjita. So, the Nepali law requires complaints in rape cases to be filed within 1 year of the incident. And until 2018, this period was only 35 days. Can you please share with us how you are working together with, along with the five female lawyers, on eliminating the statute of limitations?
Thank you for the question, Lara. I need to go a bit on the background on like how the case, the PL came to be and how we are working on. So, as you said, until 2018, the statute of limitation to file the cases, complaint of rape was 35 days. And when the National Penal Code was introduced, it came into action, the statute of limitation was increased to 1 years. But once again, like the incidents that had happened before the introduction of the National Penal Code, the cases had to be registered, like they were not able to get registered because of this 35 days limitations, and then in May 2022, something happened, like a video came out in the Nepali TikTok of a model, uh, saying that how she was abused and again and again, and she was raped by not once but multiple times by multiple people. And so it was a 20-part series of videos, and she said like what happened to her. But at the same time, in one of the videos, she also spoke that how she is not able to take the complaint now because of this statute of limitation. And there was huge uh, outcry in the public about this. There were a lot of protests happening. There were a lot of support for the victim survivor themselves, but at the same time, the criticism of the law itself. And it is one of the incident that also became very prominent catalyst for us to bring the case to the Supreme Court of Nepal. Uh, to tell you, before this we had only been like advocating through meetings or through advocacy events that the statute of limitations might be extended, or if not possible to be removed at all. But then this case, I think it was also the emotions and how everything worked together for the at that time. It was a group of like-minded people coming together at a particular time, I would say, that we were able to bring this case. And since the registration of the case itself, like it's not the single PL at the Supreme Court, I would say, there has been another PL as well, which is lobbying for extending the statute of limitation on the cases of the rape itself. So there were a lot of advocacy going on, and this two particulars public interest litigation that was filed. Since the public interest litigation has been filed, we there was the initial hearing of the case. So, and after the initial hearing of the case, the Supreme Court said, like, decided that, okay, now this case can go further. This public interest litigation issue can go for further, and have asked the written response from the government. We have received the, by we, I mean the court, have received the written response from the government sites, and now we are waiting for another hearing dates to be scheduled at the moment. And at the same time, I would also like to say that after after this incident that happened in May, even the legislatures, they were forced to like think about it. There was a lot of discussions going on about the issue itself, and in July 2022 the statute of limitation was extended from 1 year to 2 year in case of adults, and in case of minors who have been subjected to rape, they can file the cases now until 3 years after attaining the age of majority, that is from the date they of their 18th birthday. So it's a little positive step that we development that has happened in Nepal since then. But still, our fight is to remove the statute of limitation overall, so that the victims can have access to justice and there's no barrier for them to just to like go there and register the complaint itself. Like we do not want them to feel the barriers in accessing the justice. Thank you.
Thank you, Ms. Ranjita, for sharing. My next question to both Ms. Ranjita and Ms. Isabella: what are the key challenges you have encountered in your strategic litigation efforts against sexual and gender-based violence, and how have you overcome them?
Um, I think I'll just give a general overview of our key challenges. One, strategic litigation requires what you'd call an ideal client. A client that, based on the experiences we've had in courts, we sometimes, you must really look at a client who will, for the client to be the face of this matter, they must be able to have the tick of what court would ideally call this is an ideal client of sexual offenses. And so it's being able to understand that you cannot take someone of a certain stature to be your ideal client, say someone who is working, who has means. So sometimes it's very difficult just being able to identify who the ideal client is. And it's also a bit discriminatory, because then it means you have to go with a woman of a certain stature, a woman of a certain economic setup, a woman who truly carries the face and the epitome of what it would mean to be a victim of sexual violence, whilst we know that is not the true picture. Sexual violence happens to women across, depending, it has no discrimination in terms of whether you come from a rich family or a poor family. So for us, sometimes just being able to identify what you call an ideal client, that court will not go and poke too many holes, sometimes is a bit difficult. Then secondly, it is a basket of care. What would this client need to be able to participate in the process, during the process of strategic litigation? Noting that strategic litigation can take years. Rarely would you see a matter being concluded in under 1 year. And so it means you need to explain to your client that this might be a 2 year journey, a 3 year journey. Some of these strategic litigation matters you might be able to get the wind of media. How comfortable is she being the face as well as being in the media all the time? So you must then be able to start thinking what this would entail. Is she in an economic stable type of employment or not? If not, who is going to take care of her children? When she has to be in court, how are we ensuring she's able to get to court? And so it's just looking beyond what are some of, other than beyond the financial, um, what other type of counseling can this woman offer? What will you do for her children or even some of her dependents? And so being able to find someone who's able to offer you that level of basket of care is sometimes very difficult, to the point where sometimes you have to pay their rent. Which donor is actually going to allow you to pay rent for people? So that is becoming a bit of a problem, yet they want you to get a client to work with the journey of the strategic litigation. I've spoken about the time it takes to be in court, so I will not talk about that. Mm, and lately, we are seeing a trend where strategic litigation, when they're doing their judgment or ruling, we are being hit with costs. And so we don't know how to pay these costs, the costs that court is hitting us with. Because it's a very rare situation where in a PIL matter or strategic litigation matter, court gives you costs. And so sometimes we've had to go for reviews of what that entails, especially on the issue of costs. How are we supposed to We are trying to handle a matter that affects a larger majority. And so our argument has always been cost should not be the priority, considering we also do it on a pro bono basis. Then when it comes in terms of the client, to be honest, I don't think we have a solution to this. I think for us, we're at a point where we have to be very honest with the clients. We have to tell them this is what it takes. And we're also very cognizant that at any one point, the clients might want to offboard and say, I don't want this anymore. So some of these things we have not quite figured it out yet. But I would say for us, how we are trying to mitigate is being very cognizant and alive to the challenges. As such, we are also aware that this is a journey we might have to work with them, and so, depending on the matter, we also now trying to see how best we can resource mobilize um, with partners so that they can also chip in, especially in the basket of care. Thank you.
Well, in case of Nepal, and particularly in my experience, one of the challenges that has we have been facing is that, like Isabella said, the time that takes for this kind of litigations is too long. Like, for example, with the PIL that we have filed, uh, we registered the case in May. We had an initial hearing, and then we are waiting for the case, like the date. So it's been like 1.5 years already, and we have not had another hearing at all. So one of that is one of the main challenges that I see, like difficulty. And sometimes, the matters, they are high up, they are in a momentum, and when it takes like too much time, somewhere the momentum becomes slow as well, and like gaining the public interest in the matter again becomes very difficult. So I think that's one of the thing that I would like to highlight among many other things. Yeah, thank you.
Thank you, Isabella and Ranjita. My next question to both of you is, what were the arguments submitted by the government? How did you respond? And of the arguments, which do you think will be the toughest to argue?
Is this in regards to the cases we currently have in court? The arguments? Right. Um, So I think for us, maybe what I can be able to talk about, because I mean, as a law, you can, as a rule, you cannot talk about a matter that is ongoing. So for the minimum mandatory sentencing, I think for us, what I can be able to say about that is we want court to interpret what discretion means and how that is affecting minimum mandatory sentencing. So that's where we are, and that's the much I can say about it. However, on the Matrimonial Property Act matter, our argument was how our argument was the silent contribution that women make that is not financial in nature. And of course, the government argued in terms of matrimonial property is never bought using silent economy, it's financial. And so for us, the onus was on us then to be able to demonstrate that when everything remains constant, when there is peace and stability in the home, just like a country, that is when a home is able to thrive, right? And so we actually came up with a formula that I think we borrowed either from India or the UK, where they have been able to come up with a formula to contribute this, to calculate what silent economy looks like. Um, and so for us, one of the things that we all know globally, women are the ones who do a lot of the domestic chores at home, right? So we cook, we wash clothes, we take care of the children. So in the absence of employing someone to do that work, how much would that woman be paid? Yeah. And so that is one of the arguments we took to court. In the absence, in a home where this wife never had support for the cooking, the all these other chores that have to be done so that the home can run, how much would that person be paid? The second argument, as a country, I must say we are privileged enough to be able to afford nannies and other support system. And so the other argument that was taken to court is, look, She never used to do anything. All she needed to do is wake up and just supervise, right? Supervise the nanny, supervise the cook, But this is, of course, we are talking of elitist families are the ones who can be able to have this whole support system. But the supervision is also a job, yeah? Someone would have been paid to come and do the supervisory work. These children did not raise themselves despite having someone cooking. And so it's an argument that we really had to demonstrate that women are not just there for procreation purposes, that there is what we do to contribute to the peace and stability and the running of this home for this man to go out there and comfortably earn or make a living. Then the third argument that we did was in an instance where the man has come and said, I'm going to be the provider, quit your job, take care of children. Remember, these things are never said or done on record. It is in the euphoria of love, right? Where you're in love, you want to start a family. And so, one, you don't have evidence that the man told you to stop working. And so we have seen incidences in court where men have gone and said, yeah, but then now the kids are big. My last one is 10 years. Why is she still not working? So it's a conversation that now we've had to start having in terms of in a situation where a man has told you to stop working, found you working, has told you to stop working, or even never found you working but has told you categorically, I don't want you to work, I want you to run our home and take care of our children. What does that look like in terms of contribution? So we are seeing the government is slowly starting to accept that. I know there's a bill that is currently being drafted on care contribution of women in homes, which will then also lead to an economic formula that yet I'm not yet aware of yet on how to calculate what silent economy looks like. And this then will be used in decision making when it comes to the dissolution of marriages, of what it would entail for a woman to be able to acquire their equal share of matrimonial property. Oh, and just to mention that, of course, we have seen incidences now where we see a man being awarded 60-40, 70-30. Of course, it's a man who always gets the higher contribution, but for us, it's a good thing. At least women are not working out with zero contribution. So that has been the gain on this matter. Thank you.
Uh, thank you very much for the question. So, one of the prominent argument we have received in the government's response is that it's a principle of criminal law that there has to be a statute of limitation, and it's an accepted principle everywhere internationally as well. And then the statute of limitation is also very much important for the prompt investigation, collection of the evidence, so that the justice can be provided Uh, to the victim. So this is the argument that has been brought, and I think it is, I wouldn't say it is the hardest argument, but it will be one of the major argument to refute itself, because I think like in this day and age, we have to see things beyond the lens of criminal law. We have to see the things from a human rights perspective as well. And we have to see, like, a collection of evidence is one thing, but what we are talking about right here, right now, is the access to justice. And the collection of evidence comes after that. Here we are barring a victim from going to a police or an authority and saying that, see, I have suffered this thing and I want to report the case. We are barring them from providing a complaint on that matter, and we want them to be able to complain about the case. Another thing that we have to do, because the hearing has not been we have not had the hearing yet, is for us, the onus will lie on us to see, like, how many cases in the past have the court decided on the basis of hard evidences like DNA or other things, and see how many of those have been decided on the basis of circumstantial evidence or other things, like the yeah, circumstantial evidence and the victim testimony of the witnesses, so such things. So we'll also have to do an analysis of this case. So I would say that it's not hard to, like, most the toughest argument to argue, but we'll have to go like and let the court see that our intention is not for the authorities to not be able to collect those evidences, but it's better if those evidences are there. But at the same time, you also have to see beyond the evidence, and see, like, there are circumstances, and you have to take into consideration that in a very patriarchal society like Nepal, where the issue of sexual violence and other things are very much stigmatized, and still the victims are blamed for what they undergo. So we'll have to take into consideration these things and remove the limitation, so that people are able to speak on the matter when they are comfortable about it, and when they feel that, okay, without the fear of stigmatization, or without the fear of living under the shadow of the perpetrator themselves, because in many of the cases the perpetrator are known people as well. So in those cases, when they feel comfortable, when they feel loud, now they can have a voice, they should be able to. That's why the statute of limitation should be removed. It will be the way around for us to present our argument. Thank you.
Thank you, Ms. Ranjita and Ms. Isabella. My next question to both of you is, to what extent did you introduce international human rights law into your arguments, and which articles of the treaties did you cite?
Um, as a country, we are definitely signatories to various human rights legal instruments. The most popular one being the DVAL, the Elimination of Violence, and CEDAW, and discrimination. And so, in terms of sexual offenses, those are the most popular instruments that we use, especially when we are trying to argue SOA as a form of discrimination. The two articles have been able to articulate quite well and situate what that means. We have also employed or utilized the General Recommendation 35 and 19, which speak to sexual offenses and due diligence of the state when it comes to this. However, in Africa, we have two instruments, which is the Protocol and the African Charter. Actually, Maputo has been rated to be as the most progressive law when it comes to protection of women and girls in Africa. And for us, that is one of the most cited regional instruments simply because it has the African context. It takes into consideration the lived realities of women and girls within Africa. And so we were able to cite that on grounds of, we usually use the Maputo and the African, which is popularly known as the African Charter or the Banjul Charter, to talk about the issue of non-discrimination and equality. Being able just to demonstrate how gender-based violence affects a particular gender more. There's a particular gender that is adversely impacted by gender-based violence. As such, it amounts to discrimination and non-equality. We also use that tool to argue on the issue of equality before the law, something that is prescribed. So the two, you're going to find them in Article 2 of the Maputo Protocol, and Article 18.3 of the Banjul Charter. We also use the same instruments to argue on what does it mean when we say that we are all equal before the law. Why doesn't that apply in reality? How do men and women interact with the various laws within the country? And that's why you see sometimes rape cases, especially, there's been a lot of inconsistencies on the convictions. Um, how is it that a man can come and state that there was consent? Well, in reality, we know how consent works. Where is it that we are not very clear on the parameters of consent? But when it comes to certain things, men can always say, "Yeah, a no means a yes." And so these are some of the things where we are now we use these instruments to be able to demonstrate further what consent and equality before the law looks like. And then lastly, for us, we have used the general recommendations, as I said, and for us, the remedies is a very important thing. Remedies when it comes to sexual offenses for the longest time has been looked at as conviction. But we are now in a space where we are saying it has to go beyond conviction. So fine, the man has gotten his 20, or the perpetrator has gotten his 20 years. But what has been the effect to the victim? Especially where we see there's been physical injury, loss of income, self dignity, self esteem, of course, has gone down. There's the emotional turmoil. How do we then compute all this to look for awards? And so we have seen some of fantastic jurisprudence that has come from the Maputo Protocol, where we talk about remedies, which is on Article 25, where I must say within the regional human rights bodies, they've been able to award remedies, fantastic remedies, and we use that as jurisprudence. But when it comes to the implementation, is where we still have a problem. None of these states have honored the remedies or the awards that victims have been given. But but that notwithstanding, we know the law is a matter of records. As long as it's on record, it's something can be able to be used X number of years. And so for us, we're just trying to build evidence as to why these legal instruments are important and how they are contributing to the actualization and implementation of women being able to claim their rights. Thank you.
Um, Many of the international instruments and mechanism, Isabella said, is something that we evoke as well, minus the regional instruments, of course. We extensively use CEDAW in our arguments, especially the General Recommendation 19 and 35, as Isabella said. That is the basis of our arguments as well. And then we also rely on a lot of the recommendations that have been made to the government of Nepal in other international proceedings. For example, we have also relied on the recommendations of the Human Rights Committee in the cases related to conflict related sexual violence, but that can also be uh, uh, brought in the context of overall rape cases. So we have also relied on the jurisprudence and the recommendation of those cases, the cases like Fulmatiniaya, the cases like RR. So these are the cases that were in the international level, the human rights mechanism, and there have been some beautiful recommendations, UN recommendations, which we uh, try to bring in the cases that we are doing as well. Uh, Additionally, we will also rely so much on the how uh, other human rights treaty can be used, for example, for the state obligations. Maybe ICCPR could be used. So mainly we do rely on CEDAW, but we also try to see on other jurisprudence and other UN mechanisms that could be worked for the same. Thank you.
Thank you, Ms. Ranjita and Ms. Isabella. My next question is, based on your experiences, if you were to advise other lawyers who are seeking to embark on strategic litigation, what are the fundamental conditions for strategic litigation efforts to be successful?
I think, wow, it's a difficult, it's a difficult question in terms of the groundings. You know, courts are very interesting animal. Um, and so for me, one, it's something, of course, we also deter what we call forum shopping, where if you're going to start a strategic litigation matter, you must understand the courts, who is sitting where. You must be able to do the heavy lifting work in terms of going to read previous judgments that this particular court you're going to be appearing before has done, for you also to understand the language. And this I'm saying because I know of courts where when you start throwing words such as feminism, they shut down. They're like, is that a legal principle? Where does that apply? So for me, it's one I would really urge people to do the heavy lifting work of go even read 5 6 years of data of what this particular court, what has been their judgment, what are their nuances around certain issues. But even before you understand the court, before you start any litigation matter, you must have the woman question. How are you situating the woman question? In every aspect, because that is how the woman is always left out. And we only included on things where you can see squarely is about women. But in reality, strategic litigation affects women because we're half of the population, whether it's issues of resettlement, indigenous people, land, water and housing, the woman question must be there. But what do? We find it's much more easier when we are talking about how men are not able to take care of their families, whereas in reality, we know the biggest problem is how are women and children affected by this matter? How do we situate that question without going to court and court telling us, but where's the man? And so for us, it is always important. And as a practice, for us, we sit down and we do the scenario building of how to situate the woman question. How does this build and ultimately demonstrate? By just asking the woman question, we are not leaving out the man, but we are trying to situate that this is not just affecting men because it's the man who bought the land, but how do women interact with the said land? How do women interact with the said matter before the court? And so for me, that would be the most crucial thing, situating the woman question. The third thing, because the second, I started with the second, and then so for me, number one would be the woman question. Then, secondly, due diligence on the courts. Which avenue? Is it the High Court? Will it be the Court of Appeal? Will it be the Supreme Court? What are their nuances around this particular matter? Then, for me, the third one is the issue of the comparator. We go to court and we say, look, we are here on behalf of, for example, women journalists who, in the process of them doing their work, they were violated. And the court then goes ahead and asks, but weren't there men journalists in the same venue? Were they not equally violated? And this is a question that we have seen in a case where it is called the Ethiopian versus the state, where there were actually women journalists who, it's a very interesting case, you should all read it, where the women journalists were violated and they took the matter before a regional body. And the court were asking, weren't the male journalists violated? And so when you look at that judgment, the argument was, we are not here to argue about the man issue. If you even look, the comparator cannot be a man, because what befell the man is nothing close to, none of those men were raped. None of these men were sexually assaulted. It was physical, perhaps, but none of them got to experience the same thing that women experienced. And so the thing there was to be able to demonstrate to court that when it comes to women matters, the comparator cannot be man versus women. Our experiences are not the same. It has to be a woman versus a woman. And so, for example, for now, the comparator will be, what are women journalists in Kenya experiencing vis-a-vis women journalists in Nepal? That would be a fair comparator. Being able even to say, perhaps women in Nepal, yes, they go through violation, but rarely will you document incidences of sexual violence vis-a-vis in Kenya. And so for us, it's as you situate that, as you do your submissions, as you think through, always be cautious that the court will always tend to ask the man question or the man comparator. But then how do we put such a compelling story of the comparator is never the man, it has to be woman versus woman. And then thirdly, for me, it's on a more personal note, litigation for women is something else. It's the outlook that the society has in terms of, oh, how you're at the office at midnight, who is taking care of your child, who is running your home, And so from a very self point of view, as a woman, we need a support system to always remind us that these are not questions that these are questions that are going to come. These are ideologies that even fellow women are going to ask us, like, Rajita, why you awake at this hour knowing the time difference, you know? And so, how do we deal with this? Is that as if you decide to do human rights work, you must be kind to yourself, and you must look for a support system that helps you to run your home, take care of your children, and run back to when you ask questions that you know they're unfair, but you can always go to someone to talk to and cry if you need. So just always be kind to yourself when doing this work. Thank you.
Uh, from my side, I think much has been said by Isabella herself, and it's very similar to what you have said, from due diligence to finding your own support system. So, just to add to that, because I do not want to like repeat the same thing, just to add to that, to when it comes to strategic litigation, you have to be like self-aware that it can go anyway. It could be like the decision might be in your favor, and it will be a joyous moment, but it might not as well, because nobody else have done that. So now you are doing this, it's an uncharted territory for you. So, and you can try again. So one a mindset is that you have to be prepared for, but at the same time you also should be aware of this big responsibility you are taking, because if you are not diligent enough, then it is going to have a lasting impact on somebody else, a majority of the mass, and most of them women, like Isabella said. So you have to be resilient. Like, sometimes you'll just need to go home and cry and let the day be, but tomorrow you'll have to wake up again, do your research, prepare your arguments, be back there headstrong, and be resilient enough, at the same time committing to the cause that you are working for. So that would be a point from my side. Thank you.
Thank you so much, Miss
Just
Isabella.
one last thing, and I think this also applies even in Nepal. You know, for strategic litigation, when we win, it's a win for the lawyers, right? It's in court. But for me, strategic litigation is a win when it is um, when it is replicated in the community that we are fighting for in the first instance. So we are just it just massages our egos as lawyers, where we say, oh, okay, yeah, I got this win, court, so my reasoning. But as long as that is not put in practice, then that is truly not a true win. And so for me, and I'm sure even Rajita will agree to this, strategic litigation win is when it is translated back in the community. If we were fighting for matrimonial property or even the limitation of statute as they have in their country, this then has to translate into the woman knowing and understanding this is what exists, and this is how I can claim my rights. Thank you.
Thank you, Isabella. Thank you, Ms. Ranjita. Um, we can move on to some concluding questions now. And my first question to both of you is, what are your most significant successes and the impact of your work on the ground?
Hmm. So, talking about the significant success, like it's not just mine, but the whole team and everyone worked here, is that I think when we were doing strategically choosing like what we want to do and what we can do, like I always remember few of the cases that we decided to take to the Human Rights Committee, like at the UN, because we saw that okay, maybe Nepal, because of the very statute of limitation, we're not able to take the cases forward. And there we received very beautiful recommendations, as they say, to the judgments, like the beautiful recommendations to remove the statute of limitations itself, providing redress to the victim and the survivors, and uh, conducting proper investigation against the perpetrators. So it was a very much positive decisions that we had in the cases related to sexual violence, which we take as the success point. But at the same time, uh, that decision also reflected on how the victims reparations should be made, how they should get medical services or the right to education that they were not able to take. So I think in that way, uh, it was, I would like to count as a success. But translating it to the ground reality, like Isabella was saying in earlier answers, uh, not everything has been translated, and it's true. But at the same time, there have been instances where those judgments were taken into references, and the survivors have gotten some relief packages, or a human rights institution have recommended the government to provide compensation to the victims. So I think it's still, the implementation is a long way to go, but we are seeing some positive changes nonetheless. So I would like to consider that success in some way.
Oh yeah, that's good to hear what's happening in Nepal. It gives hope that the things we are doing in small pockets is translating to something. So that's a lot of hope for me. I think for us, and again, I'll just say as Rajita, it's not necessarily my contribution, but where we work and the partners we work with, and the work we have done over the years is um, since last year, Kenya to date has established 4 specialized gender-based violence courts across the country, with the intent of doing what we call survivor-centered justice, where the survivor is now in at the center. Ordinarily, it would be lawyers just offering advice to the victim without having to take into consideration what their needs are. And so now these courts are there with a survivor-centered approach. And of course, most importantly, is to be able to expedite the matters. Where ordinarily they'll take 2 years, we are now seeing matters being concluded in under 4 months, which is fantastic. Um, whether this is practice that can be maintained, we are yet to see. But at least for us, we are noting its goodwill from the government. They've taken this as a serious matter, and as such, they're putting in systems and structures for survivors of gender-based violence to be able to seek justice expeditiously and within reach. Um, and then this has also now translated to more women reporting. Of course, now the issue is clarity on whether this SGBV court will handle the whole spectrum of gendered violence, including land. So that is where we are. But at the moment, I know they're dealing with a lot of sexual offenses. This is a defilement, rape, sexual, anything that is sexual in nature and intimate partner violence. That is where we are. I think the second thing, in the spirit of also the state taking this thing seriously, a task force was formed, which I'm a part of, to be able to review the Sexual Offences Act, which was done in 2006, with the purpose of one, looking into whether there are new trends, new laws that are more progressive that should be included in ours, but also, most importantly, again, the survivor-centered approach seems to be the running theme. And so we are not just reviewing the SOA, but also its attendant laws. Which other laws speak to sexual offences, and do they speak the same language? And most recently, our partner took a matter to court because our penal code has never changed. It's still the colonial penal code, which is a bit unfortunate. And so the language, we would find language such as persons with disability, we still refer to them as imbeciles, which is such a derogatory term. And so um, once this matter was presented in court, at least our Attorney General was quick to pick and note that should not be terminology we are using in the year 2023. And so I've just seen they've circulated a draft amendment. I am yet to read it, but I have been told that that terminology no longer appears. So we are seeing some positive things. And of course, also in jurisprudence, let me not just, we are definitely seeing courts that are understanding what it means and are empathizing with women. And so we are seeing fantastic jurisprudence coming from there. But I must say that moving forward, sorry, one of the things that we must be able to do, and also in Nepal, as we continue with this work, we need to start interrogating whether our laws are truly neutral and what that means. Everyone says our laws are neutral, and that's why they talk about equality before the law. But are they really neutral? Do we have a feminist perspective when we're drafting these laws to know that this is how this law interacts with the man and this is how this law interacts with the woman? And so for me, these are the things, and I don't know how that looks like, to be honest. I just know it's something we might have to sit and think through what that looks like, as opposed to blindly just going with the law that we are taught or the law that we know. As practitioners, as people in this society, whom we need to use the law as a tool, but also as something for us to claim the rights as women, what does feminist principles in drafting of the laws look like, as well as the jurisprudence? Thank you.
Thank you so much. My next question is to Ms. Ranjita. Um, what are your future priorities and goals in the realm of strategic litigation for addressing SGBV?
I think for us it has been just a start. We want to like present we want to bring a human rights lens on how the access to justice is a human rights lens, and sometimes when we only stick to the criminal law principles, we are barring someone from accessing accessing the justice, or we are closing the doors on them. So I think it's one of the priority. This particular PIL is itself a priority, but at the same time, I think personally I would also like to foray into the other areas of SG sexual and gender-based violence cases, and be more into litigation in the coming days. That's what I think. And at the same time, another future goal is to make people aware that this statute of limitation, removing the statute of limitation, is important, and how it affects some victims unequally than other victims. For example, majority of the time it's the women who are not able to come out because of the fear of the perpetrator, because of the fear of the stigma, because of not knowing the system, the legal system itself. So I would also like, one of the priority and one thing I really want to do is work on the awareness of this issue itself also. So that is a personal priority for me. Thank you.
Thank you. And I have the same question for Ms. Isabella. What are your future priorities and goals in the realm? And do you think that strategic litigation is the way forward in Kenya?
Future priorities. I mean, we have been told laws have been drafted on the premise of the human rights standards, right, or principles. But now we know, now as the more we interrogate the said laws, the more we try to interpret the said laws, we know they are truly not taking into consideration the lived realities of communities, including the men and boys. And so for me, this is something that I'm now starting to be more interested in. What articles are out there? What is out there in terms of the law truly being appreciative of the lived realities of this community that we are in? What would that look like? And what are some of the things that we might need to consider, even as we talk about the human rights standards that were done in 1948? Do they still stand to date? Are those the same human rights? Is this why, for example, in my country, we are having coups left, right, and center, and it seems to be a normal thing? Is this why the war is happening in the country globally, and people have certain stance on what is happening? So for me, I think it's about time we truly started interrogating the lived realities and drafting laws that truly resolve the issues, as opposed to thinking of it as a blanket problem, but being able to understand the context that we are working in and what would work best for us. I am also becoming a believer in advocacy now. What that looks like. There's a lot that's happening globally, churning fantastic laws, fantastic articles. But how is that translating into anything meaningful? It's just for the elite. It's for people to read and continue churning more documents, and we use them when necessary. But on a day-to-day basis, where it matters the most, what type of advocacy is required to truly touch the grassroots women and men? What would that look like? We are very aware of the General Recommendation 35, General Recommendation 13, fantastic recommendations, but it's only fantastic for us. But in reality, it should be able to translate to the grassroots. It should be able to be used and appreciated by the system. And so for me, it would be how do we do this in a more concerted and concrete, in a more concrete manner, to ensure that it truly trickles down to the people that matter the most and the most aggrieved in this society. Strategic litigation, definitely a tool that can be used to advance and claim rights. But the system has to change how this looks like. Um, and for me, the day the America reversed the Roe v. Wade matter, it had an implication. It then demonstrated to people that something that was decided long before any of us were even born can be reversed when in our lifetime we must be able to interrogate them that what that means, because we can have this win now, we can be tears, sweat, blood, what else are we doing just to make sure we are doing strategic litigation? But we know that there's a risk of this being reversed when there's a different court. So what for me, strategic litigation still remains a very important tool, but we must now start being able to understand what it would mean if it is reversed 10 years from now when it matters the most.
Thank you so much. My last question to both of you is if you could share with us how we can contribute and help to the cases you've shared with us today, or in any other way.
Mhm. Well, one thing that I have been like telling in our past conversations as well is that when it comes to the cases like the removal of the statute of limitation itself, there's very limited resources on it, and we have found that in our research as well. So if you are anywhere in your country there has been the cases like that, or you think like there's any other cases uh, that could be of interest to us and help to us, please send it to us. I think Lara will be able to share our contact information with you as well. And then we have also like, then there are some cases that we really want to look forward to, but then there's the language barrier. For example, very recently there was a case of inter-American court that was decided on repair. One of the decision was to repeal the statute of limitation itself, but because it was in Spanish, and we have this barrier of the language, we are not able to go through it. So, if there's anyone who would like to volunteer or share the English content with us, that would also be great. So, yes, these are the specific instances, but at the same time, if there's anything informations, or if you think like there's any arguments that could also be helpful, please be open to share it with us. And I hope we can also reach out to you for the council if there is anything in the future we would like to discuss in the way forward.
Um, Very similar to Rajita, information is scarce. When you find this information again, patriarchal systems don't sleep, they work overnight, and clearly they've been working overnight since the world began. And so, even most of the information we found out there is very limited to support us in our claims. And so, for me, one of the things I think just as Council Rajita said, it's also a conversation I've had with Sahar. Mm, SOA is a global issue. It's just that we have the small unique things, but it would be important perhaps doing a litigation surgery on some of these matters, just to do that scenario building and coming now with a global look, because for what perhaps Rajita is going through in terms of the limitation of statute, that has happened before. But do we have enough information to support and be able to help her build up her case? In my case, the minimum mandatory sentencing, mm, not a new phenomenon, but where is this concrete information, especially to demonstrate that it is not interfering with discretion of the court, because this is our biggest battle, where on one hand you see what court is saying in terms of discretion, but on the other hand we are fully convinced discretion is still being upheld. But then where is the evidence? Every time we go with that, we are being told you must interrogate where this comes from. You are tying my hands. What does that mean? So I think I would want, beyond information, it would just be nice to sit virtually or otherwise to just discuss what are these things and what it looks like, and do a scenario building. Um, for me, lastly, it's the issue of remedies. Remedies for sexual offences actually means something. I don't know. I don't know who convinced us that sentencing is the only remedy, and we were happy to go with that. And now, just as I discussed earlier, we see on a day to day that more needs to be done. How do we start this work of more? How do we start? I see SAHR doing a lot of work with ICCPR, with the UN, and this are some spaces that are very influential in starting to influence um, global laws and policies. How do we start the narrative or put together something about remedies that can be used in the same regard? Thank you.
Thank you so much, Mr. Isabella and Ms. Ranjita. So um, we'll come to the end of this session, and um, thank you so much for taking the time. And today's session has been an enlightening and inspiring session, and you guys have shed light on the critical work being done by both of you, Ms. Ranjita and Ms. Isabella, in the field of strategic litigation against SGBV. Throughout this discussion, we've gained invaluable insights into your backgrounds, motivations, and the challenges that you've encountered on your paths. So thank you so much, Ms. Ranjita and Ms. Isabella, for your dedication and work in eradicating gender-based violence and promoting gender equality. And on behalf of SAHR, thank you so much.
Thank you for having us.
Thank you.